Right. Okay, just to let everyone know, we're going to give it till 2:15 on the dot, just so folks can get in. We're up to 41 folks. All right, got a few more folks coming in here. All right, we'll be starting, well, I've got 2:15. So welcome everyone. My name is Mark Piotrowski. I'm on the board of Healthcare Now, and appreciate all of you spending the weekend with us and this joining our session here. You are in healthcare under a conservative Supreme Court. What happens next for the ACA and what does it mean for Medicare for all? You will all be muted. We're going to have some time at the end for questions and answers. We'll also be doing some breakouts, and we'll go from there. I will, because I've run out of time the last couple of times, make a pitch as Mark Dedzik did earlier in the conference. The conference is a big part of Healthcare Now's fundraising throughout the year. Normally we pass the hat for those of you who've been to our in-person conferences. So I just put in the chat the link to make a donation, maybe what you would have spent on airfare or a meal while you were at the conference, whatever. That really helps us continue to do this work, bringing activists together from all over the country, working and talking about a strategy for us winning Medicare for all. So, like I said, my name is Mark Piotrowski. I'm with Healthcare Now. We're joined today by Eagen Kemp. He's with Public Citizen, and he's going to talk about the healthcare under the conservative Supreme Court. So, Eagen, I'll turn it over to you.
Thanks so much, Mark. I really appreciate you taking the tech side of this, which is the most terrifying part of any presentation in the COVID era. So hey, everyone. Just want to first say thanks so much for joining this session of the Medicare for All Strategy Conference. I hope you all have had a fantastic conference so far. So many great speakers, so many great panels, a lot of excitement about the fight for Medicare for All. Now, I know this conference is a bit different than previous years, but all of the great sessions and speakers, as well as the record attendance, has highlighted just how rapidly the movement for Medicare for All is growing. As Mark said, my name is Eagen Kemp. I'm the healthcare policy advocate for Public Citizen. It's a consumer advocacy organization that works on a wide range of issues and appears on behalf of its over 500,000 members and supporters before Congress, administrative agencies, and the courts. Guaranteed access to healthcare through a single payer system was one of our founding issues over 50 years ago and has remained one of our core issues throughout that time. Today's session will focus on the ACA case that began oral arguments on November 10th, 2020, Texas v. California. I'll highlight potential outcomes, steps the Biden administration may take in response, and implications for broader health reform, including Medicare for All. So it's a bit of a complicated case, so I want to give a brief overview, and then we'll jump to introductions so that you folks can talk to each other because the connections are crucial here. But I want to give you a bit of an overview of where I'm going to go. So I'm going to touch on 4 key areas: the context for the case, some of the major issues at play, potential outcomes, and of particular importance for this conference, what it could mean for future health reform. Within each section, we'll try to break out into discussion groups, as I'm sure folks have their own thoughts on this landmark case and its implications as we await the Supreme Court's decision on it any day now. So before we dive into the case, I want to do a quick 5-minute breakout of groups of 5 to 10 folks so folks can introduce themselves to each other, because the connections that you make at this conference are one of the most valuable parts of the conference. And so, as you're doing your intro, give your name, your organization and affiliation, and briefly, what made you pick this particular session of the conference, and what are you hoping to get out of it? And so it would be great if somebody in the group could volunteer to maybe give just a few of the things that people raised as what they hope to get out of this session, so I can hopefully meet your needs as we go through.
All right, and I'm going to create it now. You'll have 5 minutes, and then you'll get a little 1-minute warning for those of you who've been in there, and everyone can go. We'll be set there now.
Deutsch.
All right. For those of you who are just joining us, we are in breakout rooms. So introduce yourself. So I'm going to go through here and add you each to a group at random, and you will be shipped there. All right. All right. For those just joining us, we are in we're in groups introducing ourselves. So I'm going to ship you there now, and everyone should be assigned to a room. And you should see a little dialog box on your screen to allow you to get plugged into a group. All right, folks are coming back from our breakout right now. Apologize for the folks who were in the waiting room. I was actually in breakouts and couldn't figure out how to get back to the waiting room. And as soon as we have Eagen back, we'll turn it back over to him. All right, hopefully we did not lose Eagen. Let me see here. All right, folks are filtering back in here.
Okay, great. Thank you so much, everybody. I hope that went as smoothly as possible. Looks like we do have most everybody back. So does anyone want to sort of start out? You can raise your hand in Zoom, just giving a sense of sort of what people wanted to get out of the session, or any sort of other broad comments you wanted to make, just as before I dive into the context for the case. Yeah, it looks like Elizabeth Cave.
Yeah, hi. Take my hand down real quick. The group was really interested on the possibilities of the outcome of the case and the impacts that would have on our organizing efforts. Specifically, like if the ACA loses, like what happens? Will it make for more trust for our governments, for the citizens, like feeling that the government's ability to serve the needs of citizens will be eroded? It's also important, people are wanting to take this information back to their organizing groups, because we see that, part of advocating for healthcare is understanding it within the context of the legalities of healthcare reform, and also like what these mandates like that are being challenged right now, what do they mean in the context of us citizens being forced to pay for private healthcare? And because and knowing this information is important so that we can be proactive instead of reactive.
Great, that's all fantastic. Looks like we've got Rachel DeGolia, a familiar face.
Hi, Eagen. So I think we have varying levels of awareness of what the lawsuit's about. So you might want to start at 101 with the lawsuit for people. There's a lot of concern if it's actually repealed, what that's really going to mean. It's not anything we want to wish for, even by any means, but it is something we might want to think about. What do we do if that happens? And I don't know how likely that is. I don't know the latest on the litigation, so we're looking forward to hearing that.
Great, thanks, Rachel. And then Tanya.
Hi, so I'm working with Whole Washington for Washington State Single Payer Healthcare. And I am interested of how this is going to affect the states. So if we have a single payer healthcare for Washington State and try and put that through, and the ACA is challenged like that, is that going to affect our state's ability to build our own single payer healthcare? And that worries me. And I wanted to get a perspective on that.
Great. Well, thanks so much. It seems like a lot of good things and a lot of stuff that I will hit on, but there will also be, time at the end for additional questions if there's something that I didn't hit on that you really want to sort of dive into. So as Rachel asked, luckily we are starting out with sort of a bit of background. And I just want to give a quick note that much of my summary is based on an amicus brief that Public Citizen submitted to the Supreme Court. I'm going to put that in the chat just so that folks can reference it later. It's in a bit more technical detail, so I'm going to give sort of the overview. So this case, Texas v. California, really kicked off after the 2017 Tax Scam Act. It was officially known as the Tax Cuts and Job Act, but as we all know, it was just a tax scam. And so GOP attorneys general started this lawsuit, and sort of the technical part of it is that Tax Scam Act set the individual mandate penalty to $0. Now, it's important distinction that they didn't strike out the individual mandate. They just set the penalty to $0. And I'll go into why that's an important distinction in a moment. And just sort of stepping back on the individual mandate itself, while I think most folks are familiar with what the individual mandate is, it's good to remember that it was really controversial when it originally passed and has remained controversial and has faced numerous legal challenges. It even faced Supreme Court scrutiny, and the individual mandate itself was upheld as constitutional in the 2012 case NFIB versus Sebelius, where the individual mandate was interpreted to be within Congress's power to level a tax on Americans that were without health coverage, though with many hardship exemptions and waivers. Now, this is an important piece because as many of you are seeing in the news right now, there's a whole big discussion about what can the Senate do with such a narrow majority through another arcane process known as budget reconciliation. And so that plays a particularly key role here because it will play a central part of the congressional action this term. And so one brief aside that sort of illustrates this and is deeply relevant for this case is how, so when Republicans were initially working on their Tax Scam Act, they wanted to strip the entire individual mandate as opposed to just setting the financial penalty to $0. This would have likely prevented this case from ever happening, as it was the strange situation whereby the mandate still exists under law, but no longer generates revenue. That was the sort of the crux of the issue that the GOP attorneys general used to claim that there was no longer a tax being leveled and therefore that the entire law was unconstitutional. That came because the Tax Scam Act itself was passed through reconciliation, in which all provisions must have at least some effect on revenue, spending, or the debt limit. This is some of the arcane process known as the Byrd Rule. And so if every part of that bill doesn't meet that, except for some exceptions, it can't be included. As such, because the GOP is generally dedicated to hurting Americans' access in at least some way, and we're particularly doing so in that term, and despite all the outpouring of support from activists to protect the ACA as we build towards Medicare for all, that the Tax Scam Act included the rather obtuse step of just zeroing out the mandate penalty. I will say it's a cautionary tale because Democrats have sort of the thinnest majority right now and will depend on Vice President Harris to break ties. And so many policies will likely have to be passed through reconciliation, which may set up other potential lawsuits where there may be confusion due to last minute changes when you're trying to meet some of these arcane principles. And so also important to note related to California v. Texas is that the parties involved in the case have shifted some from February 2018 when the case began. It was initially filed as Texas v. US, but as most folks know, the Trump administration chose to change its position and argued that the entire ACA was invalid once a December 2018 ruling from a lower court came out. In December 2019, the Court of Appeals for the Fifth Circuit upheld that December 2018 decision that the individual mandate was unconstitutional because it no longer generated revenue. This brings us to what will likely be the major issue at play based on comments at the Supreme Court during the November 2020 hearing on Texas v. California, which is a sort of a legal term that's, we're going to get in the weeds a little bit. So if anyone has any questions, definitely feel free to fire them off and I'll try to hit them as I go. The legal term is called severability. And so severability, I want you to bear with me a little bit, but you will be able to impress your friends at the end when the case gets decided and you were ahead of the curve. So severability would allow the court to strike certain parts of the ACA down as unconstitutional while leaving other pieces of the law in place. So to put more simply, the question before the court, and this is something that came up throughout the discussion, the oral arguments, was, does the individual mandate serve to be such a crucial piece that other parts of the law would fall if it goes away? And so we have seen in a number of recent Supreme Court rulings that Justices Roberts and Kavanaugh, surprisingly, have indicated openness to severability generally. And a number of their comments throughout the oral arguments in this case highlighted an openness of severing the individual mandate from other parts of the law. Now, where that severability happens is going to be a crucial piece in terms of the implications of what they end up deciding. So were they to declare the individual mandate severable from other parts of the ACA, you could imagine a situation where a majority of the court would uphold most of the ACA while potentially striking down the individual mandate or the individual mandate and some closely related pieces, including potentially some aspect of subsidies or the exchanges. In our amicus brief, we argued that, along with California in the US House of Representatives, that the argument that the individual mandate itself is unconstitutional is incorrect. However, even if the court decides that a constitutional challenge to the individual mandate has merit, which would invalidate, at least the individual mandate, we argued that severability under the court's precedents, which we sort of lay out in that document that I posted, would make it incumbent upon the court to uphold the rest of the ACA as one of the key pieces of this. And again, to sort of get in the weeds a little bit, is severability really hinges on whether Congress would have rather had no law at all or the law absent this particular piece that they're trying to decide whether it's severable or not. So in this case, is there enough congressional intent that they would rather have no Medicaid expansion, no state exchanges, no subsidies, no consumer protections if the individual mandate is struck down? And we argue that given how many of the provisions of the ACA are not directly related to the individual mandate, we argued it's unfathomable to say that the entire law should be struck down if the court finds the individual mandate unconstitutional. Also, when the GOP passed the tax scam bill and only zeroed out the individual mandate, they themselves were making a case for severability, as they did not go back and then also pass separate legislation that overturned the entire ACA. So just to go a bit more into detail on the outcomes, and then we'll jump into our next breakout discussion, where I'm going to ask you folks to pretend to be Supreme Court justices. So get ready to put your Supreme Court hats on. So, one of the first option, and this one feels a little unlikely, is that the court could uphold the ACA in its entirety. This would mean reversing the lower court and holding that the individual mandate, even absent the penalty, is constitutional. This has always seemed somewhat unlikely, and this was even before the Supreme Court took on an even more right-wing bent. Even if the status quo is maintained and the ACA found constitutional, the circumstances under which they decide to uphold the ACA would still have wide-ranging implications. There are significant decisions to be made on standing in the case, and just as a reminder, standing is the ability of the plaintiffs in the case to actually bring the case before the court. I'm not going to get into those because those are even more in the weeds than is probably helpful for the discussion of healthcare more generally. But there are some important pieces. So even if they uphold it, there's going to be some important decisions made. They could also vote to strike down the individual mandate and other parts of the ACA, depending on how narrowly they define that severability. For example, most narrowly, this could mean just striking out the ACA mandate, the individual mandate, and leaving the rest of the law intact. Somewhat more broad could be to strike down some aspects of the exchanges that are dependent on the individual mandate, which could have implications for state and federal ACA marketplaces, as well as subsidies for consumers and possibly even consumer protections. Much more broadly, and most terrifyingly from sort of happening in the middle of the pandemic, it could mean striking down the entire ACA, including the exchanges, the Medicaid expansion, funding for additional health priorities, protections against discrimination for pre-existing conditions. It could mean the next day we're sort of thrown back to the days before the ACA, where insurers had even more power than they do right now. Now, just briefly how I think it will go, and then it'll be your turn to talk to each other about how you guys think it's going to go. One of the major factors at play in sort of how I think about the case is Roberts' fear of having the court perceived as overly political. And that was one of the pieces that sort of the questions that one of you, or suggestions about things to talk about, is Roberts has consistently made decisions and voted for things that some were somewhat surprising because he was afraid of how the court would be perceived. I think that fear is particularly heightened right now, given, and I see some comments and questions about this in the chat, because of court reform, which should be an acute fear for Roberts right now, as Dems have retained the House and won control of the Senate and White House. And if there was going to be action on court reform, whether it's term limits, whether it's additional Supreme Court justices, huge decisions like these would play into the activism around it, the political will for it, and the potential, genuine potential for it. As such, sort of a number of legal scholars believe that the court is likely to rule the individual mandate unconstitutional, but how much farther they go is unclear. Given sort of Democrats taking over both chambers of Congress and the White House, I doubt the Supreme Court will go much further than that. But as we know, the Supreme Court often throws us a curveball, as with the ACA decision, when it was ruled that the federal government could not hold back current Medicaid funds as an inducement to get states to expand their Medicaid programs. That was a curveball that no one was really sort of talking about ahead of that ruling. And so with this particular ruling, I think we could see some similar challenges and questions. And obviously that Supreme Court decision has led to the deaths of tens of thousands of Americans who go without coverage because conservative state legislatures have refused to expand Medicaid. And so now that you've heard a bit about some of the key factors in the case, including severability, I want to put you all in the position of a Supreme Court justice. How would you vote on whether to strike down the ACA? How would you vote on whether the individual mandate is severable from the rest of the Affordable Care Act? And what sort of factors would play in your decision? So for this breakout, we're going to do around 15 minutes, and we're going to do it in groups of 9. Actually, let's do 10 minutes because I see we're moving rather quickly through our time. We'll do 10 minutes in groups of 9, just like the real Supreme Court, so folks can discuss and then come back and report out. So, have a volunteer be ready to just, talk for a minute or so about what your decisions were and what they were based on.
Unfortunately, give me a second here. I'm having to recreate the rooms here. And what I will mention too is if you're someone who spoke in the last session, let's take a step back. Let's let other folks in your group contribute to the conversation. I was sort of popping through and saw that, maybe that wasn't happening. We'll give folks who haven't had a chance to talk do so. So let me recreate. Okay, so we're gonna have 8 rooms. Sorry about this. And so you said 10 minutes, Eagen, is that right?
Yep, let's do 10.
Okay, and you'll get a message just like last time that you've got about a minute left, and then you'll all get shuttled back in here. And I've got 8 to 9 per room. And you don't get to choose which Supreme Court justice you are, right? Someone asked that in the chat.
That's right. That's right. Okay. You're just a generic one, but if there is one you want to base yourself on, that's fine.
We're all Ruth Bader Ginsburg, right? Okay, here we go. All right, everyone should see on their screen a little box to move to a room. So and I'm going to stay here. Eagen, apparently last time some folks were trying to get in and I couldn't admit them from the breakout room. So I'm just going to stay here during the breakout.
Okay, that sounds good. I'm going to stay in here as well and grab the questions out of the chat as well, just so I can answer anything that folks are asking.
And so we'll have about 20 minutes when folks get back.
Okay, great.
For folks still in the main room, if you're unable to move, I can manually move you if you want. So if you'll type in the chat, if you're here just because you'd rather not move to a group, or if you have some issue moving, I can move you there manually. So just let me know via the chat, or you can unmute yourself and just tell me. Eagen, we got about three and a half minutes left. Anything you want me to chat into the group? Just a reminder that for maybe one person to
Yeah, that sounds good. Yeah, just a
make
reminder
a
to have a
report
volunteer.
back. Okay.
Yeah, that's perfect.
And are you looking for them to make report backs on just the sort of arguments, or an actual, like, our court was at a 9-0 split, or?
Yeah, I mean, at first I was thinking of asking for that for the vote total, but I don't know how easy it is to get a group to actually get to a vote. So
Yeah.
so maybe just how it went and sort of what you guys where consensus was or something.
Okay.
Like that.
Okay. All right, we got about 30 seconds, and then I'll close the rooms up here.
Great, thanks.
Now here we're just in breakout rooms, and we're ending them in about 20 seconds. So I'll just leave you here, and we're all coming back. So just so you know what's going on, having just joined the group. All right. All right, everyone's got about 60 seconds to come back in, it says. So. It's like maybe there's some good discussion because people are taking their time getting back in. So that's a good thing.
Side.
Yeah.
some close votes.
All right. Everyone's filtering back in. We were saying that that everyone didn't jump back in meant there was probably some good discussion. So we'll turn it back over to you, Eagen, here.
Thanks. Yeah, so we've got some splits. We'll see. Who wants to jump in first and tell us a little bit about sort of how your discussion went and sort of if you did vote, what your vote was? Just raise your hand via Zoom. And
I'll jump in.
Great.
Our group, after a fair amount of discussion, voted 7-0 to go with severability, just get rid of the mandate. Although there was at least 3, maybe 3.5 of us who were ready to just ditch the ACA and throw it to Congress and maybe go make that the initiative to go with single payer.
Great, thanks so much. Charlie Swanson?
Our group was pretty much the same. We had all 7 of us thought that severability would probably win in the court. At least 3 of us thought there would likely be some curveball, but we couldn't ever figure out what we could imagine that would be. We just think it is very likely. So, and we're trying to think, well, what the heck could it be? We don't know.
Inquiring minds would like to know. Lynn, why don't you go next?
Okay, well, our group did feel that that they wouldn't strike it down and severability would win the day. However, we had a majority opinion that if we'd been in the Supreme Court, that we would strike it down and we would immediately hope and lobby the Congress to pass the emergency bill that they have before them already, all ready to go. And scoop up everybody who's lost their insurance. So we voted to go off the high dive. So.
Thank you, Lynn. Marissa?
Hi, we had a similar vote to everyone else. We pretty unanimously believed that it was better if parts were severed rather than the whole, so that some kind of safeguard could remain in place. We also talked quite a bit about how the ACA could be a stepping stone or a placeholder as other legislation is considered and comes through, just because it is a long process to get something all the way up to the Supreme Court. And our fear was that harm to the communities and to people who needed that safeguard to fall back on. That's what won the day for us, I would say.
Thanks, Marissa. And finally, it looks like we have Tanya.
Hi. So our group was a little kind of confused about how to, each one of us was going to identify as a justice, that we didn't really understand the whole idea behind what they would choose. In general, we talked a lot about the different options that were available. In the end, we kind of thought that we probably would not see an overall removal of healthcare, primarily because it could affect the way the whole United States is going to view the Supreme Court and what their roles are, and whether the implications of what Biden would do in response to having a conservative Supreme Court that would be so controlling of what the Congress had options to push through. So that's what we kind of thought, or the few of us that actually commented on. We didn't have a full 9 person vote, so that's how it was.
Very helpful, Tanya.
And
yeah, thanks.
We would like more information, like if you have more information about how this process works, that's something that we're looking for.
And sorry, which process? Just the sort of the how it will come down, that sort of thing?
Yeah, just a description of what the Supreme Court, if you could do that,
Yeah,
like give us a
have to.
background before we go into like what we think the justices are. If we could have an outline of what you think, being schooled on this, what the justices would do, to give us a perspective.
Yeah, so this is a great question, and this is sort of one of the pieces of the vagaries of the Supreme Court that I think is worth touching on before I sort of jump into sort of, you know, what I'm thinking about when I'm thinking about Texas v. California and what it would mean for Medicare for all versus future health reform. So the Supreme Court, you know, I sort of made it simple for you guys to sort of have like one big vote, but really the way that it works is that you can have justices, even if you had, say, like a 5-4 decision or something like that, those justices within that 5-4 decision could have numerous different opinions. So you could have, the four, you could have, whatever group of sort of more liberal justices says, we think, the law should be upheld as constitutional overall. But if their only option is to join a brief in which severability is there, and so it's only the issue of the individual mandate being declared unconstitutional, they may join that 5-4 decision and say, the law itself remains constitutional absent the individual mandate. And then you might have a combination of conservative and more liberal justices writing on various decisions. And so you could have, 3 that are working together, and that, would be led by one of the more liberal justices, maybe 2 are being led by the more conservative justices. And similarly with the dissents, you can have, 4, however many votes in dissent, but then each of those dissenters can choose to have their own dissent. So you may have, among the most conservative justices, regardless of how they, decide, writing about that the entire law should have been declared unconstitutional. That would not be shocking to see a Clarence Thomas write something like that, even though he's not going to be in the position to actually overturn it. And so depending on how those different pieces play out, each of those decisions will be something that court watchers and future courts will look to as they decide, how to interpret, other lawsuits around the ACA, because I think there always will be them, and other lawsuits around whatever the Biden administration chooses to pass. And so that brings me to sort of, my thinking on the next steps is that regardless of the outcome, the Biden administration will face significant pressure to pass at least some modest and immediate legislation in response to COVID-19, and potentially to shore up the ACA, depending on how the Supreme Court rules, at least in the short term. And then the Trump administration, had sabotaged numerous aspects of the ACA and healthcare and the healthcare system more generally, rending our already frayed social safety net even further. In addition, the various holes in our fractured healthcare system have obviously become gaping chasms due to COVID-19. And if the law is struck down, which I think is unlikely, and I do think it would mean huge demand for larger reform, as some people have pointed out in the chat, which Medicare for All would benefit from. I'll tell you one thing, that when I'm meeting with skeptical staff and members of Congress, one of the things that gets them to think a little bit differently is when I point out how easy it has been for the administration and the courts to sabotage the ACA, but how hard it has been for the Trump administration and the courts to make problematic changes to the Medicare program. Each year, the Trump administration in their budgets had huge cuts to Medicare, but they weren't able to actually get those implemented because people are afraid. It's called the third rail of American politics for a reason. And one of the other challenges that we're going to see, and this is really relevant to some of the folks that states that are talking about sort of some of the state issues in the questions, and I know in some of the groups, that states and municipalities are facing huge gaps in their budgets, and meaning they'll have to cut back even further in response to COVID and the recession. It'll create even more challenges in the US for people getting the care they need. And given the right-wing makeup of the Supreme Court, anything that does get passed, whether it's the Healthcare Emergency Guarantee Act, as people are pointing out, which would cover the out-of-pocket costs regardless of your source of coverage, or cover your full cost of care if you are uninsured, those are going to likely face significant challenges in the court. And also, we can likely expect big setbacks in the area of reproductive justice, which will obviously have huge implications. And again, as we sort of saw with the curveball in the previous Supreme Court case related to Medicaid, and I think Charlie's right, it's tough to tell what the curveball is going to be, because that's what makes it a curveball. And then sort of another key piece is that an increasing number of Americans are losing their insurance as they lose their jobs due to COVID-19. And so, it's going to be a lot more people, I think, are going to be open to hearing about Medicare for All. And I know the folks on this in this session are going to be pushing. And one of the places that, you know, we could always use more help is the coalition doing work on Medicare for All state and local resolutions. And this may be a time that, you know, state and local resolutions are able to sort of get off the ground in even some unexpected places because they're facing so many cuts to their care or fear about, you know, how a state or a locality keeps themselves going. And then just sort of a final thing before we jump into any sort of questions that folks have is that, you know, regardless of what the Supreme Court decides, one of the real dangers is if there are only sort of small fixes instead of Medicare for All. And some of the key reasons for that is that our public health system would remain underfunded and unable to respond to COVID-19 pandemic, as well as future pandemic, racial disparities in health resulting from institutional racism, and historical underfunding of care for Black, Indigenous, and other communities of color will continue to mean higher rates of preventable morbidity and mortality. Healthcare will still be tied for employment for around half of Americans, leaving them at risk for losing coverage during the ongoing pandemic and the recession. And moderate reforms, crucially, will not address the fact that profit perverts incentives throughout our healthcare system. Whether we are talking about insurers making record profits by not providing care during COVID-19, hospitals being bought out by private equity companies and charging patients more, or big pharma finding any excuse to drive up the cost of their drugs even during a pandemic. Our healthcare safety net continues to fray, meaning far too many people face unmet medical needs, challenges finding things like mental health, struggles to afford long-term care, and folks who are undocumented continuing to suffer and die simply because our system is broken. And without reform, without Medicare for All, there's no reform that can really address all of those issues. And so now we'll jump to some questions. I'm going to start with the ones that folks have put in the chat already, and then we'll go to folks raising their hand in Zoom. One of the questions was about, you know, would the loss of the individual mandate cause folks to pull out of the exchanges? So far with the zeroing out of the mandate penalty, we've seen less of a drop than anticipated in terms of the number of folks on insurance. Some of the early expectations were for a few million folks to lose insurance. Now, that being said, that this is still relatively early. And so some of those drops could be coming later, especially once the court rules and it becomes clear to a number of folks that they hear that there's no individual mandate penalty. I think we would see some losses. And as a lot of folks in the session know, it's a big problem because it means that it's sicker people that are left on the exchanges, which could then also lead some insurers to drop out because they don't feel like they can profit in quite the same way. I realize we've only got 5 minutes left, and I saw that Tom raised his hand relatively early, so I'm going to go to you first, Tom.
And it's quick. Eagen, could you give us an idea of when we might expect a ruling from the court?
Yes, that's a great question. So a ruling could have happened as early as this week. So I was not sure what version of this talk I was going to be giving. So I was hedging my bets that they weren't going to do it. But yeah, so no, any time now it could happen. The earliest people were thinking was around now in January. But so you know, keep an eye out, keep a SCOTUS watch, and other places are going to be tracking the cases that are coming out. So I think we'll be seeing quite a bit of action soon. Carla, looks like you've got a question. Carla Sand.
Carla, you can unmute yourself now.
I have
There
no
you go.
question.
Oh.
I don't know how that came up.
No worries at all. Tanya, it looks like you've got a question.
So my question is, because we did have less of a drop in the people who actually enrolled in the Affordable Care Act, even without the mandate, would they take that into account to identify that the mandate isn't really necessary and constitutionally required just for the way that the law is set up?
So generally speaking, they wouldn't. I mean, it could be helpful for severability in that, you know, seeing that the law continues absent the mandate. But oftentimes the sort of the originalists on the court don't care about the actual implications of their decisions. It's just whether it meets their sort of constitutional bar, which is its own issue and varies from case to case. It looks like Judy, you had a question.
Well, it really doesn't relate to the Supreme Court, but I wondered what public citizen thinks about Ro Khanna's bill that would allow the states.
Yeah, so state single payer, that's going to be another crucial area of the discussion. In the Mark, you may want to mute. It sounds like background. So yeah, state single payer is going to be a crucial piece. We had endorsed Ro Khanna's bill in the last session. It sounds like they're planning to introduce it, and there's the potential for a Senate side bill this session. State single payer, as folks have pointed out, is a crucial way for states to make some progress. And during the Biden administration, we're going to need to make as much progress as we can in as many areas as we can. And so there's no reason that, states like Washington, Oregon, California, New York, can't be moving forward with improving their healthcare system. I mean, obviously there are some limitations to what can be done through state single payer, but the Biden administration had expressed some openness and Sanders and progressives like you folks on the call, Medicare for All activists, did really a good job pushing that debate that Biden felt the need to give some on openness to states taking broader steps, up to state single payer. And so one of the things that we're going to be doing is really pushing the administration early and often on helping states expand waivers. I think if there's any silver lining to some of the insane stuff that Trump did with waivers was showing that they can go further than people would have thought. Obviously, those were states taking it in a bad direction through Medicare, through Medicaid block grants and other things like that. But on the flip side, progressive states should be able to make some progress further than expected in waivers. And those early discussions, Becerra has expressed potential HHS appointee Becerra has expressed some openness to those sorts of efforts of states making progress. And I think that will be helpful as the Khanna bill gets introduced, because we'll know what areas really do need either more waiver specificity or sort of more general opportunity for them to make changes.
Thank you.
Then looks like you've got the next question. Mark will set you to unmute in 1 second. Oh, looks like you're remuted.
Okay, there we go. Sorry. The Ro Khanna bill, the 5010, HR 5010, that consolidates the waivers for states. One of the major pieces of that I see is the protection from ERISA, which I think took down Vermont, or largely the IBM threat there. What is your feeling about that? And do you think that's sufficient to be able to protect the states from that situation?
Yes, it's a crucial question. And just to step back so folks are familiar. So ERISA, at a high level, it creates limitations on what states can do when they're regulating certain types of plan, most commonly in sort of our parlance, employer-sponsored insurance. And so it's always been a challenge because it's one of the pieces that even as states, as you point out, Vermont, try to sort of, square the circle and figure out how they get all of their funding streams to work in the same direction, they just haven't been able to touch. And that is a key piece of Khanna's bill, really taking on ERISA sort of head on. And I think what they've got in there should work. I think, as we're talking about Supreme Court, it's a crucial piece. That's definitely one of the pieces that would be challenged early if passed, because insurers stand insurers don't like being regulated generally, and they do a very good job stopping both states and the federal government from regulating them. And so they are going to definitely go after that piece and lobby, and not just if it passes, but lobby very hard to stop that from getting through committee, from getting through a floor vote. And so that's going to be a crucial piece, but something that we need to work on. And one of the things that we're having discussions now with a number of folks is whether there's ERISA tweaks we can make in the interim that, you know, feel less threatening, that start to make changes and start to erode that huge brick wall that is ERISA, and the challenges that it creates for states, and doing more on healthcare and doing better on healthcare.
Thank you.
All right, I see that we are past time, and so I just wanted to thank everyone so much for joining. It's been a fantastic discussion, and I'm looking forward to connecting with many of you in the future as we continue the fight for Medicare for all together.
Yeah, thanks, Eagen. I just put in the chat, and I'll put it in again. For any of you who knew the late Don Beckler, I encourage you to go and watch the memorial that we put together. I put the chat in the link for Don, and also another plug to make a donation for Healthcare Now for our organizing work. Our next session is, let's see, we're at 4:15 Eastern time, so in about an hour. There's the Where We Go From Here, Lessons from the Movement. From now until then, I encourage you to use the Gather app and go and continue these discussions, find some folks to answer those strategy questions that we frame the conference with. It's always a great part of the in-person conference, and we've done our best to try to replicate that here. So thanks so much for, Eagen, your time, and everyone for joining this workshop and being part of the conference all weekend long. And like I said, this video will be put up on the Sketch app once we get a chance to get out of the conference itself and get all that up there. So if you want to share it with folks, that's where it'll be probably later this week. Thanks again for everyone, and have a great rest of the day.